Nothing on the show is to be construed as legal advice. The contents of this show are for informational purposes only.
Hi, welcome to Know Your Rights to Consumer Lawcast with me, Abbas Kazerounian. I've got my very special guest this week, Dave McGlothlin. Dave, we're living in some special times right now.
It's definitely some crazy times. Everything's up in the air right now. Just trying to get through this.
I mean, a month ago, would you have expected to have been working remotely like this with this coronavirus pretty much dominating world media, world news, and everything that's going on in kind of modern world society, really?
Right. Honestly, it seems like it happened overnight. I was actually on a trip and I did a trial, and then I emerged from trial, and it seemed like the world was falling apart. So,
so for the viewers and the listeners, David was actually in the office, and he was basically very, graciously taking a day off his vacation to come into the office to train an associate, and literally this was all going down, and Dave and I were talking, and I said, Dave, I really think you should probably head back to Arizona by 12 o'clock or whatever it was, and literally you did, right?
As soon as you suggested that, I just packed up and left. I called the wife. I was like, we're loading up the car. We're heading back.
Well, it wasn't funny, but it kind of was. Trying to see the funny side of things. Anyway, I hope you listeners and viewers that you're all keeping safe and, socially distancing yourselves, as they say. So today's show, Dave, what I really want to talk about is really 2008 and kind of the correlations to how, we can learn from the lessons of 2008 crash to today of what's going on. Inevitably, if you've been following the stock market, notwithstanding yesterday where there was a kind of a sudden shot upwards, the stock market has been plummeting. And, the stocks are crashing. A lot of people are already losing their jobs. And, people are scared because whether it's paying rent, paying bills, it's kind of going crazy right now. I mean, have you noticed a trend in that regard as far as how people are reacting and, their job security, et cetera?
Yes, for sure. People are definitely scared. They're getting sent home, they're getting locked down, and for a lot of them, that means no pay. And so no pay means immediate financial distress. Unfortunately, most Americans aren't equipped for an emergency of this sort. And so, unfortunately, this pandemic is causing a lot of financial strain on a vast majority of America.
Yeah, and I think only today the Senate approved a $2 trillion kind of package to try and help the American people get through this time, and how that's going to be divvied up and the details I haven't got into the nitty gritty yet, but I think sometimes it's worth investigating that if you think that you are going to be in trouble, whether it's paying your mortgage, and the government's there to assist. But I personally haven't read any of the issue, got into the weeds and read the fine print. Do you know how that's going to affect people yet or not?
I don't know yet. I've only seen a couple blurbs. I thought that I saw one thing that said that the relief checks could still take 4 months to come. So it might not be as immediate as we want it to be, as people need it to be. So hopefully the government can help, and hopefully they will step up. But at the same time, I think consumers need to be educated and aware of what's going on as well.
Right. Okay, so one of the main lessons that I really kind of want to go to, as I said, we're going to draw parallels on 2008, is bankruptcy, essentially. There was an unprecedented amount of bankruptcies between 2008 and 2012 after the market crashed. And as I was, even today, we're still dealing with the aftermath of those bankruptcies in people's credit reports and all of that kind of good stuff. But one of the things I was seeing is that people were filing bankruptcy on $5,000 debt, $10,000 debt, $15,000 debt, which to a lot of money, I totally understand it, is to a lot of people is a lot of money. But I feel like a lot of people rush to the bankruptcy option without really exploring other things. And, you and I have worked with each other for a very, very long time. And, we do consumer law and the plethora of it. So, like, what are the kind of things that, like, people can do to educate themselves and learn a little bit more about their other options before they go down that avenue of bankruptcy?
Yeah, first, I really suggest that consumers treat bankruptcy as the last resort. It is the final straw. It's the nuclear option, in my opinion. There's a lot of statistics out there. The number one cause of bankruptcy is medical emergency or medical bills. And so when I have a consumer calling me to file bankruptcy over a $3,000 debt, a $5,000 credit card, there's rules on how often you can file bankruptcy. And so when they're trying to file bankruptcy over such a small amount, I ask them what happens if a year from now you have some sort of medical emergency and $100,000 in medical bills. You can't file bankruptcy at that point. You've already just filed it over a $5,000 debt, a year ago. And so you have to be cautious. This is a tool that's afforded to you, but in my opinion, it's a last resort. And before you get there, I think that there's a lot of consumer protection statutes out there that could help you solve these same problems. Just starting with the debt collection statute. There's a statute out there that says what debt collectors can and cannot do. And so a lot of times consumers are considering bankruptcy because they're getting hounded by a debt collector. Well, in my opinion, you should consult with an attorney. Let's see if that debt collector is following the law. Maybe they're not even following the law in their collection attempts, and you can solve that problem that's being created with the debt collection statute instead of a bankruptcy.
And I mean, just to interject right there, if this is the first podcast you've listened to or watched on the Lawcast series on Know Your Rights, there is one of the first episodes that we ever did was on the Fair Debt Collection Practices Act, which is what I think you're referring to. Correct. And my guest on that particular show, Mona Amini, and myself, we go through the whole kind of, the day-to-day major things that come across our desks under that statute. So, consumers know what the big playing items are. Like, for example, if you have the right to tell, debt collectors to stop contacting you. When you send them a letter and they call you, you have a violation, whether they contact third parties, be it if they can't use profanities, threaten you with deportation or arrest or, criminal conduct. That kind of stuff is explained in depth on that podcast. So without trying to duplicate what, things that we've already discussed, if that's something that's happening to you, you can really, really, really learn much more about that by listening to the other podcast after you're done with this one. But I don't want to completely stop talking about the FDCPA because I think it is such a kind of overlapping issue with bankruptcy because a lot of people, when they go to a bankruptcy attorney, they have multiple creditors. And, very, very few people, because, at our firm, we do bankruptcy too. And, that's one of the things that, the services we offer, but we always use it as a last resort. And when a bankruptcy client comes into the firm, unless they have a $100,000 medical bill, which does happen, most people, the majority of people have 10 creditors. They have 3 credit cards, their mortgage, and all, you go down the list and you have a list of creditors and you have to list them down. And one thing we do right at the beginning is we immediately send a letter of representation and cease and desist to all those creditors. And probably 30% of the time, one or more of those creditors will violate that cease and desist request and bring about an FDCPA violation just by simply going through the steps of doing a proper cease and desist request, which if anybody really wants to know about is very, very welcome to call in and, email us, etc. And we'll deal with that. We'll absolutely help you. Watch the other podcast. But that's the really just that simple act alone can really, really help a consumer.
Right. I've seen a consumer want to file bankruptcy because they're getting harassing calls. Oh, I can't get this. This company is calling me every day. Why don't I just solve this problem with the bankruptcy? That is killing a fly with a bazooka. You can stop that creditor from calling you with a simple fax. And so a lot of times, consumers are just, they need to get a little more educated. There's some other tools out there that can help you save that bankruptcy as your last resort.
So one of the things that comes about with that cease and desist request also is that it brings about, if they violate it, it brings about TCPA violations, which stands for Telephone Consumer Protection Act. So, like, can you talk a little bit about that, Dave?
Right. So there's a statute out there that says that a company cannot use an auto dialer to call your cell phone without your consent. What's important about that is well, almost everybody nowadays, their primary phone is their cell phone. So that's beneficial. And then a company, they can't use an auto dialer, and the consequence for that is pretty severe consequence. It's $500 per call violation for negligent violations, and that can be trebled to $1,500 per call violation. And that's for calls to your cell phone without your consent. And so a lot of times consumers can use that statute to their advantage to handle these issues, regarding their debts.
I mean, let's think about that though, right? We're talking about people that are filing bankruptcies for $5,000 or $10,000, right? And imagine somebody sends a cease and desist, and the creditor or the debt collector, doesn't process it, or misses it, or intentionally ignores it. All three viable possibilities, and they continue to call the consumer. Now, in that scenario, Dave, I mean, it doesn't take many calls to make up that $5,000 debt.
Right. Almost 4 willful calls, you already exceeded the debt. So a lot of times we do help consumers that only have gotten a few phone calls. We can get them off get them out of the debt. But there's some consumers that have a lot of phone calls. There's as most people realize, there's some businesses, some collectors that have policies to call you morning, noon, and night every day until you answer. And so that volume of calls, their liability under the TCPA can skyrocket very quickly.
Yeah, I mean, because debt collectors don't make money by calling you once in a blue moon. They make money by calling you numerous times a day. So inevitably, if they miss the cease and desist, you're probably going to rack up some calls.
Exactly.
So one of the other issues that, people come in, it's kind of associated with credit card debt predominantly, is where people have been sued in state court for, breach of contract, basically debt collection lawsuits, right?
Right.
And we're going to have a whole episode just dedicated to debt collection lawsuits. But I think at this particular time, it's important to really address this, at least in passing. A lot of people, when they start defaulting on their credit cards, and we have so many clients that come to us, they don't just have one credit card that they're being sued on. They're being sued by 3 or 4 credit cards, right? And so they're like, well, I got to file bankruptcy. Why shouldn't they necessarily file bankruptcy without exploring their options in potentially defending those lawsuits?
Right. So a lot of the companies that are bringing these lawsuits, they don't actually have the evidence that they need to win the lawsuit. They're counting on a high default rate. They're counting on more than 95% of consumers not bothering to fight the lawsuit or to challenge a lawsuit in any way. And so with that sort of business model, there's lots of law firms and debt buyers that are buying and suing on these debts that aren't bothering to have the extra steps to gather the necessary information to win their lawsuit at a trial stage. And so, it's definitely my advice to a consumer. Let's challenge the debt. Let's make sure that they have the evidence that they need to win the lawsuit before you start handing this company thousands of dollars, or before you take this drastic measure to file bankruptcy. Let's make sure that you owe the people that are suing you and claiming that you owe them.
Right. And I think you're being a little bit conservative, to be honest with you, with saying 95%. And I know you said over. I actually just did an interview with an investigative report journalist for ABC, and it didn't get aired yet because of the whole coronavirus breakout. They wanted to have other stuff. It was actually meant to come out last Monday, and it was exactly on this epidemic of lawsuits in the United States. And I actually think it's much closer to 99% plus default rate because people don't know their rights.
For sure, for sure. And they assume, they're getting sued by a debt buyer, and it's usually some weird name that you've never heard of before. It's not who you've entered into your agreement with, but then they recognize the debt. Oh yeah, I did have a Bank of America debt at some point, right? Well, that debt buyer that's suing you, they might not have all the documentation proving that you do owe that Bank of America debt. Honestly, they might not have the documentation to prove that they own the debt that they're suing you over. And so you could run into a situation where, yeah, I don't fight it. I just, let this company, get this judgment saying I owe a debt. And then somebody else can come along down the line that actually does own your debt, that does actually, have the right to collect from you. And you're stuck, dealing with the same debt twice. So it is important to know your rights and enforce your rights in those situations.
Did you see what he did there? He said, "Know your rights." No, but in all seriousness, even if they do have the documents, this is the final word on debt defense because we're going to do a whole episode on this thing. Even if they do know their rights, actually, we're going to make two more points. This is the one. Imagine if you got a debt buyer, somebody that's bought the note from their original creditor, and the average amount on these debts that they're suing on is about $3,000, by the way. $3,000 to $3,300. And let's say the original creditor was Capital One, right? Capital One is based out of Virginia, right? And let's say the third-party debt collector is, I don't know, let's call it Midland Funding because they're the biggest debt collector in the country and they're debt buyer as well. And they sue Mr. Smith in San Diego County in San Diego, right? Now, let's say they have all the documentation, right? In order for them to prove the case, they need to bring a custodian record from Midland Funding to say this is the original and authentic document and we own it, right? And you know what? That's easy for them because Midland Funding is in San Diego. Right. But that doesn't do it if you're following the rules of evidence, does it?
Right. So they'll have to bring a rep from the original creditor. And there's no way that they're going to get some rep to travel, if in this case, from Virginia to San Diego over a $3,000 debt. So yeah.
Which means if you're in a trial situation, that evidence isn't coming in.
Correct. Yeah.
So, and here's another issue. Like, let's say you got 4 credit cards, right? And like that amount, let's say all $3,000. That's $12,000 of debt. And somebody thinks, well, that's enough money for me, enough debt for me to go file bankruptcy. And they're scared to go see a lawyer because they think they're going to be paying, what, $250, $350, $400 an hour. And if they could pay that to defend the card, it makes no financial sense. They would pay the credit card, right? But what are their options here?
Right. So there's, various options. There's, if you're going to fight the debt, our firm will fight it for a flat rate. Consumers get scared with, lawyers, their hourly rates, things like that. And so, what we do is we have a formula and it's a flat rate. There's no surprise fees, things like that. So that's one option in fighting it. But if one of these statutes is available to you, like the Fair Debt Collection Practices Act, that has a fee shifting provision. So if we found a violation under that statute, and the law says if we prove that violation, the other side owes our attorney's fees and costs. And so if we've identified a situation like that, we're able to assist the consumer with no out-of-pocket costs to them.
Right. And if you pay the flat fee, even if there's no violation, you're buying yourself essentially 2 years because you're not going to get a trial anytime soon in San Diego County or anywhere in California or most of the country. Most jurisdictions, it's going to be a 2-3 year track before you get a trial.
And now in this climate, it's actually really backing up the courts. I mean, those trial dates are going to get pushed even further. So
in California, all civil jury trials are suspended for 60 days. And unless there is an emergency hearing, there is no civil proceedings going on for at least 60 days because of the coronavirus, which is going to create an incredible amount of backlog. So imagine, it's kind of like you have a pipeline of litigation cases. You have new cases being filed, and then you've got other ones that are either being settled or going through the trial process. The problem is you're going to get a bottleneck in the middle here because we've got the 60 days. People are still filing, because they don't want the statute of limitations to run on their cases, but there's nothing coming out the rear end. And so what's going to happen is it's going to create a massive backlog in the trial calendars throughout all the courts in the country. And and most jurisdictions are following California on this 60-day suspension on the civil trial calendars. So that means that if you're in trouble right now and you're being sued, it behooves the consumer not to just immediately cave. If there is any way you can engage in that litigation, you're buying yourself a 2-3 year window to breathe and basically maybe find a job if you've been laid off, and see what you can do to maybe, and even in the worst case scenario, even if you can't beat these lawsuits by the end of the 3 years, I guarantee, well, I can't guarantee, but in a vast majority of cases, you're going to be able to get pennies on the dollar on those lawsuits rather than paying 100 cents plus interest, which is what would happen if you just let them get a judgment against you.
Right, exactly. I advise my clients that are getting sued. I say, look, let's fight the debt. Let's test the evidence. Let's see what they have. There's no surprises in trial. We get to do discovery. We get to see what they have, who they're going to bring to trial, everything. There's no surprises. So let's stall this for years in some cases. Let's stall this. Let's see, what trial is going to be like, what evidence they're going to have, and then let's reassess. And at that point, the consumer can choose to settle. If they don't like their risk, they can choose to settle. And it's usually an affordable payment plan for a vastly reduced balance.
Right. And I mean, I think you actually touched on a really interesting point, because most people watch TV, David, and they're like seeing, Perry Mason from back in the day, or, Suits or something but, first of all, cases never get to trial in the space of 30 minutes or like 45 minutes, which is one episode of a TV show. So let's get rid of that misnomer first of all. It's going to take you 3 years to get there. So what they're representing in a 30-minute window is going to take 3 years. Give or take. That's number one. Number two, there are no aha moments in trial. Right. There's really no aha moments in trial, because the way that the American jurisprudence works is that we have to hand over everything to each other before we get to trial. So I know what the defendant has, the defendant knows what I have, and it's literally, we know how, it's just a matter of how the evidence is going to shake out at trial. The only time you're going to get an aha moment is if you get somebody to lie on the stand and you've got some contradictory piece of evidence that you can spring out from under your sleeve and say, oh, no, you didn't. But notwithstanding that, there are no surprises.
Correct. No surprises. So we get to assess the client's risk before actually proceeding with that trial.
Yeah, exactly. So I think there's a myriad of reasons why, if you've been, there's lawsuits or anything like that, that's something to consider and definitely take into consideration. I think, and I think we need an episode on this, David, to deal with it properly. I'm getting a lot of telephone calls right now about, I've been laid off, I can't pay rent. And that's going to be a major issue for the American consumers over the next 90 to 120 days. Sure. I'm going to do a proper episode on this because I think it's necessary, and a lot of people fall into this category. And it doesn't necessarily go into the whole bankruptcy issue, though it may if you fall in debt. But your landlord, at least in California, can't just throw you out your house. Right. There are procedures and steps that they have to go through. They're going to take at least a month or so before it even gets to court. But as I just said, the courts are backed up right now anyway, and the courts are not hearing any non-emergency issues. So if you can't make rent this month, I'm not saying put your head in the sand. But what I am saying to you is they have to at least give you a 30-day notice period, and they have to go through all the correct steps to give the appropriate notice that's left on the door. And then you have an opportunity to make, to cure that issue, and then it starts all over again if you default again. But then even if you default and don't cure within the 30 days, they have to then go through the right procedures within a court system, which right now is closed. So I'm not telling anyone to default on their rent, but what I am telling you is, if you're struggling out there, if you think I can't make rent because, but I've got to keep a roof over my children's head, and, first of all, we're in a state of emergency, and most landlords, I hope, are in a position to be able to assist their tenants. That's number one. Number two, even if you're dealing with a major corporation that doesn't really care and is pushing back, they can't just show up and throw you out. So I'm really hoping that we're going to get a full episode on this later, because literally today I've had 4 or 5 telephone calls and maybe 4 or 5 emails just on this issue. And it's obviously a major problem for a lot of people throughout the country. And I hopefully within the next week we'll do another podcast on this one, because I think it's an important issue. But I really wanted to raise the issue on the bankruptcy episode, because I didn't have the foresight to think we should have that episode first. But I really wanted to put it out there for our listeners and our viewers, so that to know that, hey, you have options. Definitely contact consumer lawyers on this particular issue if you're having problems. But it's not the end of the world if you can't make your payment immediately if it's due.
Right. A lot of people are misinformed, and they think, they get that notice taped to their door, 3-day notice. A lot of people incorrectly think that means that if they can't pay, they have to be out in 3 days. That is not the case. You have time. You can use the court system to slow the eviction down. And luckily, there's a lot of jurisdictions in California that are outright putting a stay on eviction proceedings during this emergency situation. So be aware of your rights. Landlords might not realize that the stay is in place. So, know your rights, do your research. The government might have already stepped in to protect you.
Yeah, and I was saying 30 days before. I meant 3-day pay or quit notice. I meant 3, not 30. I apologize. So we've talked about not immediately running to the bankruptcy court, David. We've talked about the unfair debt collection laws. We've talked about the Telephone Consumer Protection Act. What else do the consumers have in their tool belt to be able to fight potential bankruptcy? There's even more consumer protection statutes out there. There's another one that deals with your credit reports. It's called the Fair Credit Reporting Act. And so basically, everything on your credit report has to be accurate. And so that's another tool that consumers should use. They should pull their credit reports, see what debts are being listed there, see what accounts are being listed there. Are they their accounts? Are there any issues with those accounts? And that's another consumer protection statute that they might be able to use to their advantage in order to address their financial distress that they're going through. Good. Exactly right. I feel like, that there is a general theme in our area of work where I feel like the worse the times are, it's the people that are most vulnerable that get hurt first, and this kind of exemplifies that exact notion. And I feel like when that happens, it goes into an upward curve of how these people are affected. And when I mean upwards, I mean badly affected. That curve goes exponentially higher. And I think it's because the people that are most vulnerable tend to, because they are vulnerable, because they are in that position, they panic and make bad decisions. And right. And if there is one message that I can get through on this particular episode, is that irrespective of how bad you think your situation is, and I'm not downplaying that it could be bad, it could absolutely be bad. Don't do anything right away. Sleep on it. Right. Don't react. Don't be reactionary. Evaluate the situation before you decide to conduct whatever it is that you're going to do. In order to deal with the situation. And I think the best thing that you can possibly do in a situation like this, specifically in a consumer context, is seek advice from a consumer lawyer, because it should cost you nothing It doesn't matter if it's not our firm or anybody. Just go see a consumer lawyer. Doesn't matter where you are in the country. Consumer lawyers are practicing law through this pandemic. We, as a law firm, are working remotely, our usual business hours, and then some. In fact, we're busier than normal because everybody's emailing and asking questions, and every single one of our lawyers at our law firm is working at home with a phone extension, email, and video conferencing. We're doing this podcast via Skype. Technology is available, and it doesn't cost a thing. If you want to look at your lawyer in the face, most of them are using Skype, Zoom, BlueJean, whatever, FaceTime. If you've got an iPhone, they have an iPhone, you can FaceTime. It doesn't cost you anything. You have that ability to contact a lawyer and educate yourself. And all good lawyers in our field would give you a free consultation for at least an hour and assist you in their areas of specialty. And they'll give, and you will be blown away by how many rights you may have and not know about. How important is that process, David?
It's extremely important. You shouldn't make life decisions spur of the moment, right? You shouldn't use your last dollar, to pay a credit card bill because a debt collector is scaring the crap out of you. Save that dollar, especially now, to feed your children.
Right. No, don't buy a scratch card.
But yeah, so there's always time to seek a second opinion, to get some advice, so you can make an educated decision for what's best for you and your family.
That's a phenomenal point. And you know what? You may not like what that first lawyer tells you. Call another lawyer and get their opinion. Get a third opinion. It's like, then you'll know. You may have a better connection with one lawyer over the next lawyer, but the knowledge is power, as they say. Okay, and the way our legal system works is that if you know the law, if you know your rights, you're more likely to succeed. And unfortunately, corporate America has all the fancy lawyers, has all the money, and they know their rights. They're not going to forget their rights. Right. They're going to enforce them to the full extent of the law. And why not arm yourself with exactly the same tools to at least have a fighting chance?
And knowledge is free. It might be the only tool that you have, but it could be the winning tool. So get it. Know your rights.
Knowledge is free. I paid 6 figures of debt to go to law school. No, but it is free. He's absolutely right. So guys, educate yourselves. And any words of wisdom before we close out, David?
Nope. I think we just touched on it. Just know your rights, gain that education on this topic, so that you can make good choices going forward.
Exactly right. And I will endeavor to come back and have an episode on the whole landlord-tenant issues that are coming up in this. And I apologize. I kept saying 30 days, and David was right. It's a 3-day pay or quit notice, not 30 days. But educate yourselves. Don't panic. Sleep on anything that's going on. Take advice. And then, after you've taken all the advice, react to whatever is going on. Until next time, guys, keep it legal and safe.